Of the Senate Rehab and Social Service Committee for 2019 will come together. And clerk, if you'll call the roll.
You have a form, Mr. Chair.
Thank you, Madam Clerk. I just wanted to let the committee know the ABC subcommittee will continue through the interim for those who worked on it this summer. We're going to have to meet at least one time so we can hear the interim report that we've asked ABC to do. The House is now on board with what the subcommittee is doing. But I just really wanted to thank the committee this morning in front of everybody to kind of tell you what we've accomplished in a pretty great, I think, bipartisan effort this year. Some of the things that we've pushed out. We pushed out the foster care omnibus bill. We did the ABC mixed beverage referendum flip. We actually got work done on distillers commissions. Senator Mason and his team worked on the Family First Prevention Service Act. We got that done. Senator Favola carried the transitional child care for VIEW participants. McClellan carried the summary suspensions for child care facilities, and Donovan brought through this committee the mental health services in local jails. So I just want to say from a personal point, thank you all for the work you've done, and I can't tell you how much it's a pleasure for me to be able to chair this committee in a bipartisan fashion and put your great strengths to work on some of these contentious issues. So with that, we're going to start. I know I've got House members seated there. They have some unique bills, but I'm going to ask Senator Cosgrove, the vice chair, to go ahead and go through the subcommittee report. And let me thank him as well publicly for the work that the subcommittee does that makes it easy for us to get through the amount of bills that we do as they grind through that. Senator Cosgrove.
Thank you, Mr. Chairman. Mr. Chairman, we'll start out with House Bill 1622. This is from Delegate Collins. The bill provides that in any civil proceeding involving the alleged abuse or neglect of a child on an out-of-court statement made by a child 14 years of age or under at the time of the statement is offered into evidence describing those acts with or on the child by another may be admissible. The bill provides that such civil proceeding, a recorded statement of the alleged victim or the abuse or neglect made prior to the proceeding may be admissible if the alleged victim is 14 years of age or younger at the time the statement is offered into evidence. Under current law, such an out-of-court and recorded statements may be admissible when the child is 12 years of age or younger. It was the recommendation of the subcommittee to report 4-0, and I so move.
Mr. Chairman.
Senator Black.
I certainly understand the position of the subcommittee and also of the House. Everybody has tremendous sympathy towards children who are subject to abuse. I've tried many of these cases involving young children, and the main uneasiness that I have is that I honestly think this probably should have gone to courts, because what you get involved in is a very delicate and somewhat moving line that deals with the Sixth Amendment right to confrontation of witnesses. And there have been some moderation, some movement made to accommodate children and their sensitivities. But it's a very delicate line, because the Sixth Amendment does guarantee an accused the right to confront the witnesses against him. And while I'm very sympathetic, I've hugged kids after these things with tears, tears flowing when we finished the prosecution. I really believe that should get a look by the courts of justice, so that whatever we do is consistent with the current state of the law on confrontation of witnesses.
Thanks, Senator Black. I will take that under advisement. I think Senator Chafin maybe could alleviate some of your concerns with regard to competent attorneys on the sub.
Thank you, Mr. Chairman. I feel like, I understand what Delegate Collins is trying to get at here, but I do feel like that this is a bill that would be better looked at by the committee that has pretty much a lot of attorneys in it, the courts committee. This is a departure from the hearsay rule, which, it just sort of, it's a great big departure from the hearsay rule. So I would, with that in mind, I'd like to make a motion to re-refer it to courts.
And I'll second that motion.
Mr. Chairman.
Mr. Chairman.
Senator Cosgrove, then Senator Mason.
Mr. Chairman, before we take that action, I would urge the full committee to report, and then if so desired, re-refer to courts. I'm not an attorney, but we did have a hearing on this bill. We had people talk to this bill, and the subcommittee did vote to report it 4-0. So if the motion would be to report and refer to courts, then I would be more comfortable with that.
Mr. Chairman, I would offer a substitute
Okay.
motion.
Substitute motion is to report and re-refer the bill to courts. Okay, that's been moved and seconded to report the bill and re-refer.
Court's meeting Monday, Mr. Chairman?
They are.
Thank you.
Mr. Chairman?
Senator Sproul?
Well, you got, you have 1, 2, 3, 4, you got 5 lawyers here, and I just got my law degree from Law and Order. Why we can't do it now? I like him, that's what I'm saying, you know.
We do too.
Okay, all right, okay.
All right, so the motion is to report the bill and re-refer it to courts. You okay with that, Delegate?
We have the compatriot bill for the criminal section has already gone through court, so I think that it's appropriate to have.
I think you're in good shape. I think they
that's
just won.
fine. I'm okay with Senator Black's motion.
Okay, all right. Committee will vote. Ben, you want to vote to send it to courts? No. Okay. I got it. Yep, okay. 12-1-1. All right, Senator Cosgrove.
Thank you, Mr. Chairman. Next, we have House Bill 1627 from Delegate Auroch. The bill requires the Commissioner of Social Services to prioritize inspections of child welfare agencies in the following order: inspections conducted in response to a complaint, inspections of licensed and registered child welfare agencies, inspections of licensed, exempt, or unlicensed child welfare agencies that have entered into a contract with the Department of Social Services or a local department to provide child care services funded by the Child Care and Development Block Grant, and inspections of licensed, exempt, and unlicensed child welfare agencies. It was the recommendation of the subcommittee to report 4-0, and I would make that motion.
All right, it's been moved and properly seconded by Senator Favola to report the bill. Committee will vote.
Nays 14, nays 0.
14-0. Senator Cosgrove.
Thank you, Mr. Chairman. House Bill 1671 from Delegate Mullen requires the local boards of social services, when investigating an individual who is the subject of child abuse or neglect allegations or the subject of a family assessment, to determine whether such individual has resided in another state within at least the last 5 years, and if he resided in another state, to request a search of the child abuse and neglect registry or equivalent registry maintained by that state. Mr. Chairman, it was the unanimous recommendation of the subcommittee to report, and I would so move.
Okay, it's been moved and properly seconded to report House Bill 1671.
Nays 14, nays 0.
14-0. Senator Cosgrove.
Thank you, Mr. Chairman. House Bill 1884 is from Delegate Keem. There is an amendment that needs to be offered, and Delegate Keem is here. Basically, briefly, it directs the Director of Department of Corrections to review the department's visitation policies concerning visitors' wearing of tampons and menstrual cups at state correctional facilities, and shall revise such policies as necessary to permit such visitors to wear aforementioned items. Delegate Keem is here, and I believe he has an amendment to offer.
David, you want to go ahead and go with the amendment?
Sure, Mr. Chairman, and obviously I leave it to your discretion. we could work with or without the amendment. The amendment would just simply have a reporting back mechanism. I've been talking to the Department of Corrections folks. They said they'd be willing to work with us with or without the requirement to report back. So it's really up to you if you know, I don't want to burden the committee.
We
any more
typically
than-
would like to get a report back.
Sure.
Because
As
it
I
falls
said, I
under
wanted
us.
it to be
and
at your discretion.
I have members that are experts in different areas, because this committee takes up so many different areas. So if there's no opposition to your amendment, we'd like to add
I'm
it.
fine with it. I just didn't want to add another
Can we hear,
burden.
David, do you want to read the amendment, please?
Mr. Chair, the amendment would be on line 14, after cups, period, insert, "The department shall make the policy available to the public as soon as practicable and shall provide a copy to the chairman of the House Committee on Militia, Police, and Public Safety and the Senate Committee on Rehabilitation and Social Services by November 1st, 2019.
all right, Mr. Chairman, I move the amendment.
All right, it's been moved and properly seconded by Senator Black. All those in favor of the amendment say aye.
Aye.
Any opposed? All right, the bill's properly before us.
Mr. Chairman, it was the recommendation of the committee 3-0, one abstention. That was me, because we still have some questions about it, but I think they've been answered, to report. And so I move the amended bill to be reported.
All right, it's been moved and seconded to report the bill. Committee will vote.
Yeas 15, nays 0.
Thank you very much, Mr. Chairman, members.
Thanks,
Thank you,
Delegate
appreciate
Keenan.
it.
Senator Cosgrove.
Thank you, Mr. Chairman. House Bill 2108 from Delegate Bell directs the Department of Social Services to promulgate emergency regulations to ensure collaboration, communication, access, and transparency between local boards and licensed child placing agencies and foster parents. The bill also directs local boards of social services and licensed child care agencies to implement and publicize a dispute resolution process through which the foster parent may contest an alleged violation of such regulations by the local board or licensed placing agency. It was the recommendation of the subcommittee to report 4-0, and I so move.
Been moved and seconded by Senator Black to report House Bill 2108. Committee will vote. Who has Senator Hanger's proxy? Thank you.
Yeas 15, nays 0.
15-0. Senator Cosgrove.
Thank you, Mr. Chairman. The next is House Bill 2208. This is Delegate Brewer's bill. There are two amendments that are going to be offered, but it expands the applicability of adoptive procedures for a child's close relatives to all the child's adult relatives, including step-parents, step-brothers, or step-sisters, and all of, other adult relatives of the child by whole or otherwise, marriage or adoption. It was a recommendation to report 4-0, but there are two amendments that are being offered.
Mr. May, would you please offer the amendments? And Delegate, you're okay with the amendments? Okay.
Mr. Chair, the First Amendment would be on line 13, after by, strike whole or half blood, comma, and the second is on line 13, after marriage, strike the comma.
Any members have a question on
I move the
that?
amendments, Mr.
All right,
Chairman.
it's been moved and probably seconded to accept the amendments. All those in favor say aye.
Aye.
Any opposed? The bill is properly before us.
Mr. Chairman, I move to report the amended bill.
It's been moved and seconded to report the bill as amended. Committee will vote.
Yeas 15, nays 0.
15-0. Thank you, Delegate. Senator Cosgrove.
Thank you, Mr. Chairman. House Bill 2258 deals with child care programs, exempts parents and other persons who participate in a cooperative preschool center on behalf of a child attending such a cooperative center, excuse me, including such parents or persons who are accounted for the purpose of determining staff-to-child ratios from orientation and training requirements applicable to the staff of child daycare programs. And the bill provides that such exempt parents may be required to complete up to 4 hours of training per year. It was the unanimous recommendation of the subcommittee to report, and I so move.
All right. It's been moved and seconded to report House Bill 2258. Committee will vote.
Yeas 15, nays 0.
15-0.
Thank you, Mr. Chairman. The next bill we have was House Bill 2280. This is Delegate Head's bill. We heard the bill in subcommittee and was a unanimous recommendation to report 4-0. But with that being said, I do know that Senator Hanger had some questions about this, whether this was kind of an end around about a previous agreement. So if we do report this, and I see that Senator Hanger is not here, this may have to go to finance. All right, so Delegate, do you want to briefly tell us, the bill and then
Sure.
basically what Senator
And
Hanger.
Mr. Chairman, what we have here is there are, I think last year we had a group of, or a shift in what we were defining as child daycare programs, and we broke it into 3 different sections. We had a section that was, these are not daycare programs, then these are daycare programs, but they are exempt from licensure. And then finally, the third category was the group that was required to be licensed. And in gathering up all of these things, one of the things that got swept up in it was programs that are offered at a school by school officials after school, and or that were offered after school by the school but are taught by employees of the local government, from the Department of Recreation. Those had never been considered daycare programs before, and they got swept up in that code section to be ones that were exempt from licensure but were still considered to be daycare. What that will require when this goes into effect in July is that those school systems that offer those programs would be required to post signs that say, this is a daycare program, but it is unlicensed, and we're notifying everybody about that. The thing that's interesting about it is that if it was a private group in an off-site location offering the exact same programs, they are not considered a daycare program. So it really put it out of phase, and we think it should never have been put there to begin with. And so what we're trying to do is just pull it back and put it in the appropriate code section. We're literally just moving it from one place to the other. That's the only thing we're trying to do with this.
Mr. Chairman,
One second, Senator Black.
if I could, just a question. So a church summer camp or some sort of a private summer camp type of thing, they're not going to be affected by this, are they?
Not at all, no, sir.
Okay, thank you.
All right, Mr. Chairman,
Senator Cosgrove.
that being said, and,
No, please.
I'm sorry?
Go ahead, would you
I'm
like?
going to defer to you.
Oh, okay. Mr. Chairman, it was the recommendation 4-0 to recommend reporting, but I'm going to change that recommendation to report and refer to finance to see what the impact may be in there.
All right, Mr. Chairman, if
Yeah.
I could then. I'm Sue Rowland, and I represent a number of different clients, and I'm the source of the discomfort that the senator has. So I want to explain that to you all. And it may or may not have an impact on the motion that you just made.
Mr. Chairman, I will, if you don't mind,
Not a
I will
problem.
tell you that regardless of what has to be said here, we heard it in subcommittee, finance has asked for it.
Okay.
You know,
Okay,
It needs to go.
okay,
okay.
we can
This
kill it,
is not
we can
a
kill it or send it to
intent
finance.
to, right.
Yeah, it needs to go there, and I'm fine with finance taking a look at it. I have no problem with that at all, so.
All right, so my motion is to report and refer to
All
finance.
right, it's been moved and seconded to report the bill and re-refer it to finance. Committee will vote.
Nays 14, nays 0, abstention 1.
Okay.
You're out of
Thank you,
here.
Mr. Chairman.
Senator Cosgrove.
Thank you, Mr. Chairman. House Bill 2743 is from Delegate Moorfield. This requires any individual who is the subject of a child abuse or neglect investigation or family assessment to notify the local Department of Social Services prior to changing his place of residence and provide the local department with the address of his new residence. The bill also requires the Department of Social Services to document and report to the governor and to the General Assembly by November 1st, 2020, on the number of individuals who notified a local Department of Social Services of a change in address and provided updated contact information between July 1st, 2019 and July 1st, 2020. It was the unanimous recommendation of the subcommittee to report, and I so move.
All right, it's been moved and seconded to report the bill. Committee will vote.
All right.
Senator Cosgrove.
Yes, sir. Finally, Mr. Chairman, we have Delegate Miera's bill. It is House Bill 2756. And this exempts from licensure any child day program in which the child minding services are offered on the premises of a small business for no more than 4 children under the age of 13 at any given time, and for no more than 8 hours per day, provided that the parent or guardian of every child receiving care is an employee of the business who is on the premises of the business and can resume responsibility of the child's supervision within 30 minutes upon request. It was a unanimous recommendation of the subcommittee to report, and I so move.
All right, it's been moved and properly seconded to report House Bill 2756. Committee vote.
Ayes 15, nays 0.
Okay, that is 15-0. Mr. Chairman, does that complete your
That completes my
supplement?
report, sir.
Okay, thank you. Okay, we're going to go ahead and take up in the batting order that we have here, and I think we have, yeah, let's take Delegate Knight. You have one ABC bill, and
Yes, sir.
before we start on your ABC bill, I think we have two amendments to that bill.
Yes, sir.
I would like to explain one amendment to the committee as a result of yesterday. Delegate Knight has graciously allowed me to put an amendment on his bill, this bill that's before us, and David has crafted that amendment. But yesterday, some of the work product that was a part of this committee was defeated in the House, and a portion of that work product found unanimous agreement in both chambers was the Sproul Amendment that we talked about, enforcement of folks who violate M-bars. And with Delegate Knight's permission to his bill, he's allowing us to put the Sproul Amendment on his bill, so we could do that. So David, if you'll read that, and then what Delegate Knight's other amendment does to the bill.
Mr. Chair, so I'll first go over the two line amendments from Delegate Knight.
Okay.
The first of which would be on line 81 after by, insert either Romanet 1, and then on line 82 after permittee, we have a few lines of text here, so bear with me. Insert or an independent contractor of the permittee, provided that the permittee has entered into a written agreement with the independent contractor, establishing that the permittee shall be vicariously liable for any violations of this section committed by the independent contractor relating to any deliveries of beer, wine, or farm wine made on behalf of the permittee, and B, only one individual takes possession of the beer, wine, or farm wine during the course of delivery. The other amendment that was just discussed by Chairman Reeves would be, and this would cause the bill to be reported as a substitute rather than amendments, would be the addition of the code section 4.1-111, which deals with ABC regulations, and specifically, it would be the addition of a new subdivision B23, which would require the ABC board to promulgate regulations that, and this is where the text starts, that prescribe the terms and conditions under which the board may suspend the privilege of a mixed beverage licensee to purchase spirits from the board upon such licensee's failure to submit any records or other documents necessary to verify the licensee's compliance with applicable minimum food sale requirements within 30 days of the date such records or documents are due.
The substitute. Okay, the substitute before us has been moved and properly seconded by Senator Mason.
Could, Mr. Chairman,
Yeah.
could Delegate Knight tell us what the angst was with the chairman's bill?
Let's get the, let's get them substitute. All right, been moved and properly seconded to accept the substitute. All those in favor say aye.
Aye.
All right, any opposed? All right.
Now can I hear why they don't like your great bill?
Well,
I don't think it was
voted for
there.
it yesterday, and I made the motion.
That's exactly right. Go ahead and tell us what we're doing here.
Yes, sir. This goes, HB 2367 goes to delivery permits. I'll give you an example. You're at home, you call Kroger or grocery store and say, I would like to get my groceries delivered plus beer and/or wine. And when they bring that to you, it requires records to be kept for 2 years of the quantity of beer and wine that were delivered and the types of beer and wine, and to make sure that a remittance of all the taxes. And the one amendment down here allows for, if it's, there had to be an employee of, say, Kroger, but now they can get someone different to bring it in there as long as it stays in their possession the whole time from the store to the delivery.
So this is to address some of the, Grubhub and like those
Uber
type
Eats,
of
yeah.
new businesses that are coming online that are doing delivery service.
Mr. Chairman?
Yes, sir.
Senator McDougal.
Who is the independent contractor? Is it Grubhub, or is it Joe Smith or Susie Smith who's driving the car for Grubhub?
It's it's all of the above that
Miss-
enter into a contract with the store or the Pizza Hut or whatever.
Mr. Chairman,
Senator McDougal.
I need to know who is signing that contract and who is going to assume the liability? The individual driver or the platform entity?
So, Mr. Chairman, members of the committee, Jeff Palmore on behalf of Uber, and we worked with the chairman and the wholesalers. So if the delivery is done by through a motor vehicle, then that would be covered under the property carrier legislation that we all worked together on a few years ago, amending.
Mr. Chairman,
Senator McDougal.
I don't think so, because that is requiring insurance for the vehicle, and this says vicariously liable,
And
that's a different type of liability,
Sure.
so.
Perhaps Mr. List can address that part, because that was
Well,
dealing with ID.
Okay,
check.
I think you have a lifeline through my attorney, David.
Mr. Chair, Senator McDougal, I believe here, and you're not looking at the language, so I can see how this come up. What it says is, the permittee shall be vicariously liable for any violations of this section committed by the independent contractor. So basically what it's saying is, not in relation to any civil liability, but if you violate the terms listed in this section in Title 4.1 as far as what you have to do as an ABC licensee, then if the independent contractor makes that violation, that's going to be imputed back to the permittee, so they would be able to be punished or reprimanded by the board in the event that they violated one of the ABC provisions.
Senator McDougal, does that help as you noodle on that?
Mr. Chairman,
Senator Mason.
so for the non-lawyer in the family, following up with Senator McDougal, so if they take the 12-pack and a bottle of wine and stop on the corner and give it and sell it to somebody or give it to somebody, who in that case is the Uber driver liable? Is the platform liable? Who's responsible for that?
Mr. May, I think you just said the permittee.
So
Mr. Chair, Senator Mason, well, there would be multiple liability here. So there would be a violation on behalf of the permittee through the independent contractor if they stopped on the corner and, say, gave alcohol to someone who was underage. That liability would be imputed back to the permittee for purposes of violating 4.1 and having it reprimanded by the board. With that said, the independent contractor who physically sold or gave alcohol to someone underage, I think what could also be held criminally liable for committing a crime as well.
Mr. Chairman?
Senator McDougal.
So under this language, it says the permittee has, which seems interesting term as opposed to shall, entered into a written agreement. So we're directing them to enter into a written agreement, but what if they don't? So then, and the person delivers the alcohol to somebody who's either interdicted or a minor, then they would be in violation of this provision, but they would not have their license subject to being revoked for selling alcohol underage. Is that not accurate?
If they're not entered into the contract, then it's a non-issue.
Well, Mr. Chairman?
Yeah.
So they have Uber's delivering groceries for them or Grubhub or whoever. They deliver, they don't enter into this contract. The delivery is made to somebody who is underage or interdicted. They've not entered into this contract. They are then subject to violations of the provisions of non-delivery, but the permittee is not subject to having their license revoked because a minor or interdicted person received it because they didn't enter into the contract. So shouldn't we say, as a matter of law, the permittee is vicariously liable for the actions of the contractor instead of it making a written agreement, make it as a matter of law that they're in violation, period?
Mr. List.
I would say, Mr. Chairman, members of the committee, you are correct But the permittee, which is the retailer that's licensed, is equally could have their license suspended or revoked for engaging in a violation of 4.1212.1 because they did not have that written agreement. The written agreement establishing vicarious liability is a current requirement for ABC for any agents who are making deliveries. This would just have the same language for independent contractors. But I think as a technical matter, you're correct. The permittee could not be held liable for a violation of 4.1305 for sale to a minor, but with the same penalties could apply for a violation of 4.1212 because they did not have the written agreement. So either way, the retailer will be held responsible for that unlawful delivery, as well as the criminal penalties that can be brought against the driver or the independent contractor.
Do you want to work on it?
I hear what he's saying. I'm trying to, are the penalties, Mr. Chairman, and this is maybe for ABC, I see John back there, are the penalties for violation in this section the same as they are for violating 41305?
You guys want to come up from ABC? I'll tell you what, do you want to, we'll have this temporarily go by and you guys step off over there and cut through it a little bit, or do you want to?
Well, Mr. Chairman, this question will probably resolve in my head,
Okay.
my direction. I don't know if it'll resolve their direction.
Tom Kirby with Virginia ABC. Mr. Chairman, Senator McDougal, a violation of 4.1212.1 could result in a civil penalty or suspension of a license similar to what you would face under 4.1305. We do have those set penalties for 305, which is typically a $2,000 civil penalty or 25-day loss of license. That could be more or less for one of these types of violations.
Okay, so that's the max?
That's our first penalty. We do have a negotiation now that we're an authority. We sometimes work with the licensee. If they're going to go to training, we'll reduce that amount down. But we do have listed in our regulation that these are our first offense, which is usually the max.
Okay. Does that resolve it?
So I'm sorry, we were having another conversation here. So you say the penalty is more or less for violation of 305?
It could be the same penalty. The board could assess the same penalty, or they could assess a penalty that's even higher than that because it is a different violation. So for sale to an underage, we have a standard penalty that we use for a first offense, a second offense, and a third offense. There is some negotiation there. And for a violation of, not using an agent or something like that could result in the same penalty, or depending on the seriousness of it, it could be slightly higher than that, or maybe slightly less, to your point. But they would be held accountable. So any violation of regulation or code that comes in our, charge manual results in, a hearings violation report, and that can be handled either through a civil penalty or through a suspension or revocation of a license.
Mr. Chairman,
go ahead.
As I understand what they're saying, I would feel more comfortable if the penalty under this section, using an independent contractor, is in addition to any penalties that would be under 4105, and they would be as a requirement that if you violated this section and it also violated the other one, you'd have two penalties. This is going to be pretty wide open because even though it might be one person, you're going to be contracting with a TNC to call and pick it up, and they don't know who's going to be the one that goes and picks it up individually and takes it. So I do have some concerns about the opportunity for abuse is greater here. I'd like the opportunity for penalty to be more stringent as well. But I might be the only one who feels that way.
Well, I think that's a good discussion. So Delegate Knight, what are your
Belt and
feelings?
suspenders is fine with me.
Okay. Tom, you're okay with it? Okay, so are you making that motion in the form
Mr.
of
Chairman, I
motion?
think, and David would have to craft the specific language, but penalties under this section would be in addition to any penalties that would fall from a violation of 4105 arising out of the same incident. Yeah, 4.1305, sorry.
Mr. Chair, Senator McDougal, just to clarify, I guess if I got an example of exactly how this would work and under some specific facts, I could figure out a better way to craft it here. It's my understanding that it appears you don't want just a violation of this section, but also a violation of 305. I'm just trying to figure out if it would be that the independent contractor would violate 305 and that would be imputed back to the permittee separately?
Yes.
Okay, so they would be possibly have criminal liability for the actions of the Uber driver.
Mr. Chairman, I'm not necessarily worried about, that's much harder to do, have the entity have criminal liability for that, because even if the entity's employees or direct employees sells, the entity itself is not subject to criminal liability, they would just be subject to civil liability. So you wouldn't, a corporate board member or CEO would not be subject. So it's civil penalty.
So you got it, David?
What I want to make sure is that they get 2 fines or 2 days or multiple time license suspension, not.
Yeah, there could be an administrative charge against the licensee for both the violation of 305 and the violation of 212.1.
Yes.
Okay.
Mr. List stated it much more succinctly.
So as David tries to wordsmith this, is the committee comfortable with going with the intent of the agreement?
Mr. Chairman, I would move those amendments in concept, and David can have that ready for the discussion on the floor.
Okay. So in concept, because he's good, but he's not that fast, go ahead.
If we're going to do it in concept, Mr. Chair, just to clarify, would we want to limit it to vicarious liability for violations of this section and 4.1-305, or would it be this section and any other section in Title 4.1?
All right, hold on.
Just be about whether it's limited to underage.
Mr. Chairman, I'm more concerned about the interdiction and underage, so I'm okay with 4.1305. Because that's where I think that this is the biggest opportunity.
Let's do this.
So I think.
You got it? Okay. Okay. Everybody good? I'm looking around. Okay. All right, so David's going to draft that amendment up to the substitute. It's been moved and properly seconded that that amendment be adopted. All those in favor say aye.
Aye.
Any opposed? All right, the bill is before us. Does anybody else wish to address the bill, or committee members have a question on the
The
bill?
report is adopted, Mr. Chairman.
Second.
All right, it's been moved and seconded to report the bill, the amended substitute. All those in favor vote aye.
Case 15, nays, 0.
Okay, 15-0. Delegate Knight, David will get the amendments out to us just so we have that clarity, but you'll need that to get, so when he's done drafting, I'll make sure he gets you a copy of that to you.
Thank you, Mr.
Thank you,
Chairman,
Delegate.
members.
Delegate Poindexter.
Thank you, Mr. Chairman, members of the committee. House Bill 2749.
Committee will bring their attention to 2749.
Substitute, you should have the substitute.
All right.
I'll just bring this
Let
because.
me get that before us. Okay, there's a committee. Oh, a substitute. Okay, go ahead. I'm sorry, Delegate.
It should be in front of you.
Yep, we got it.
I simply bring the bill because of the numerous inputs from the constituents of mine. I've checked with other legislators. There is a perception among many in the citizenry that perhaps the TANF electronic cards are misused from time to time or significantly or maybe not at all. So I bring the bill which would require DSS to report annually violations of the use of those electronic cards. Their fraud unit already collects this data, and the data can be put in an existing report that they file every year.
Okay. Senator Cosgrove.
Delegate Poindexter, in your bill, and I'm sorry, I don't have the text right here, who's going to get that report? Normally, we define not just the General Assembly, but usually
Wherever that, Senator,
Line 19.
yeah, I don't know the answer to that question, but they were required to file that report, and whoever gets that report would, just in addition, get the fraud data.
Well, Mr. Chairman, if I might offer, as we've seen in some of these other bills, I would offer an amendment that that report be delivered to the chairman of HWI and Senate Rehabilitation and Social Services.
Delegate, typically, we've seen these, Senator McDougal was the first one to come up with and make sure that if we're going to ask people to do something and put time and effort into it, that those committees that actually govern them get the chance to look at it rather than go to a black hole and people get it on their desk and it gets filed somewhere, so.
I have no issue with that.
Okay. All right, so we have a friendly amendment to specifically add HWI and this committee on to that report.
I have a quick question.
Senator Favola.
Good morning.
Good morning. I expect that this information is contained in the complete report, which also shows efficiencies and the number of TANF cases, the magnitude of the program, so we have some context for understanding.
I'm not aware of
the
that.
error
Maybe
cases.
DSS is here and could answer that question.
Good morning, Mr. Chair. My name is Tony
Morning.
Washington. I'm with the Department, Director of Benefit Programs. It is a fraud report that calls out all the benefit programs, and it speaks to a fraud that's identified and the error trends and things like that. And so it does not speak to the specifics that you just identified, but it's something that we could add if the
Mr. Chairman,
Senator
follow-up
Favola.
question. Is it a federal requirement right now that this,
It's not a federal requirement.
So it's a
something that the
state-
General Assembly requested of us some years ago.
some years ago? Okay. Mr. Chairman, I would just say while the department rep is here, it can be misleading sometimes when you're just reading a report that only shows a negative and doesn't really show the magnitude of the program, because Virginia actually has one of the lowest error rates in the administration of TANF in the entire country. And that
Well, what the report does show is that the fraud rate for TANF specifically and other programs is that the fraud rate is less than 1%.
which is admirable when you think about it.
Yes.
Thank you, Mr. Chairman.
Okay, so.
Mr. Chairman? Delegate, Mr. Chairman?
Can I just
Oh,
add
I beg your pardon.
the motion was to add the two committees to the report. Any discussion on that? All those in favor say aye. Aye. Any opposed? Okay. Go ahead, Sir Mason.
Delegate Poindexter, you just heard the lady from DSS say that we're less than 1% fraud, and you said you brought the bill because of the perception of fraud. Why do you think that is?
Well, I think it's because the use of the cards, and when people go into a store and they see other people buying lottery tickets and beer and wine and whatever, and they're just unconcerned. They're working people and paying taxes, and they just want to make sure that the system is efficient as it possibly can be.
Mr. Chairman, one more?
Sir Mason.
So really, it's just the overriding opinion of people reviewing those, using these benefits and deciding whether or not they're using it appropriately.
Not just opinion, Senator. I have anecdotal information where constituents come to me and say, I saw so-and-so and I saw so-and-so, and they were buying lottery tickets or buying beer or wine or tobacco. And that's a pretty strong complaint that I feel I have to answer to.
Mr. Chairman, one more, I'm sorry.
Senator Mason.
How do we change a perception?
I can go back with the data here or any other legislator and say, look, as Senator Favola mentioned, if our numbers are that good, and go back and say your concerns, you shouldn't have any concerns. This is how it works, and we're doing well.
Thank you, sir. Thank you, Mr. Chairman.
Great point. Senator Black, did you have a question, or you good?
I would move to report.
Okay. Okay. Okay, one second, Senator Bosco. Mr. May has one technical amendment he needs to throw to it.
Mr. Chair, just to accommodate the amendment offered by Senator Cosgrove, on line 21, after May, we would also need to insert also, it looks like the original intent here was to have a report to the General Assembly, and then a clarification in the last sentence that the report has to come either way, but it may be included in this fraud report that's already being submitted pursuant to 503. So this would say it must go to the chairman of these two committees, and may also be included in the fraud report.
Okay. It's been moved and seconded to accept that amendment. All those in favor say aye. Okay. Senator Boysko. Who was first? I don't know who was first. Senator Locke.
I have a question for the DSS rep. To alleviate the concerns about the anecdotal information, can someone use an EBT card to purchase alcohol or tobacco?
Yes.
Okay. And can you, again, state the amount of fraud in using EBT?
Across the
Or-
TANF program,
or
it's
the
it's
TANF
less than
program.
1%. But that's a combination of many things, not just for these particular instances.
Senator Boysko.
Thank you, Mr. Chairman. Just to follow up on Senator Locke and the answer that you just gave us, if we already know that it's less than 1%, I'm not certain that we need to invest in an entire new report if you've already got the data. I'm curious to understand why we would need this information if we already have it. Thank you.
Right.
Senator Boysko, in the early stages of the bill, we looked into when the electronic card is presented to the vendor, to the merchant, that there is no way, there's no software, there's no capability to determine what is being purchased with that card. So I would say to you that the opportunity for fraud is much greater than what we think it is and what we're proud of.
Senator Boysko.
Thank you, Mr. Chairman. But Mr. Poindexter, our representative has just said that it's less than 1% of, there's less than 1% of fraud. So I'm not,
Again,
I guess
don't-
I'm just not understanding what new information we're going
Senator
to get.
Boysko, if you'll let the delegate respond, don't run him over. Delegate.
There's no way of knowing, because at the point of transaction, the item or items being purchased, it can't be determined what they are. So if you have an unscrupulous merchant or an unscrupulous tenant, they could buy anything in that store with that card. And that's why I don't necessarily question the 1%. I hope it's true. But I think this gives us an absolute, it gives us more information to see if it's worth investigating further.
Thank you. Senator DeSteff. Okay. Senator Favola.
I just want to clarify. Thank you, Mr. Chairman. Delegate Poindexter, there used to be, because I used to work in this program at the federal level, and there used to be a requirement on states who were receiving the drawdown payments to actually produce federal error rate reports. Is that requirement still in place, and why couldn't the federally required report, which gets at the information you want to get at, why couldn't that satisfy the question that Mr. Poindexter, the problem Mr. Poindexter is trying to solve?
Senator Favola, we have requirements for the SNAP program to issue error rates, but we do not have that same
So it was
requirement for the
removed.
TANF program.
The TANF program requirement was removed.
Okay. All right. Senator DeSteff.
For the young lady from DSS.
I'm sorry.
What is the amount of TANF that's given through the state of Virginia?
So we're under a federal.
I understand it's federal and state. But
block grant.
yes. What's the total amount that the state of Virginia issues under TANF with the federal grant?
It's around 150 million, is that correct? I'm sorry. Our TANF manager is right here.
Mark Golden, TANF manager. The total block grant that we receive is 158 million. Around 65 to 70 million is spent for TANF benefits.
Okay.
So the total is 165 roughly?
Okay. 158.
158, I'm sorry. Okay, so I mean, this is, the fraud that we know about is less than 1%. That's like saying, well, we ticket about 1% of the speeders out there. We know there's more than that happening, but we only catch 1% of them. It's like when we say, oh, we caught this many attempted hacks on our system. Well, we know that we catch about 1% of the attempted hacks on our electronic systems. But there's, on top of that, there's a tremendous amount more that just walk through. So I understand the intent of the bill, and 1% of 158 million is still $1.6 million. So we are talking about a significant amount of money. And when we say that you can purchase beer and wine with your TANF card or your EBT card, I know the original intent of TANF isn't to purchase beer and wine. So I think this is a good bill, and I think we should pass this bill.
Senator Cosgrove.
I move to report the bill as amended.
Okay. It's been moved and seconded to report the bill as amended. Committee will vote.
Even though the delegate tabled my really good Leo bill yesterday.
9-6, delegate, you're out of here.
Senator, did not table your bill. I left it on my docket. If we want to come back and take it up, sir, I will make sure it just happens.
There you go. You heard it.
Thank you.
That's a recorded tape. Delegate Aird.
Good morning, Mr. Chairman and members of the committee. You should have House Bill 2005 in front of you.
Committee will bring their attention to 2005. Go ahead, ma'am.
All right, thank you. House Bill 2005 comes at the recommendation of the Virginia Department of Social Services. This legislation would simply bring the code in line with federal regulations to allow children to retain their eligibility up to the age of 19 if in secondary school or equivalent on a full-time basis, regardless of the graduation date of the child. So it's really simple, just conforming to the federal age.
Okay. If the bill reports, it still has to go to, we've got a financial impact statement on it. Do you?
That's right. It's in the budget, so I understand.
Okay. All right. All right. It's been moved and seconded to report and re-refer to finance. Committee will vote. Okay, we have
I thank the committee.
15-0. I think we have one bill left, 1987, Delegate Toscano. The committee needs to know that this is similar to Senator Obenshain's bill that came out of rehab on the 25th. It reported out of rehab with the substitute that was 15-0, and if we conform it, we'll need a substitute to make the following changes. Have you talked to Senator Obenshain?
No, but I've fully expected, being here, that it would be conformed and work out the differences.
All right, so David, do you want to go through what those conformities will be, or are you all good since you heard the bill and it came out of here 15-0 and we can go with it? Okay. So is that a recorded vote to conform? Okay. All right, the motion is to conform House Bill 1987 to Senate Bill 1490. The committee will vote and report the bill. Do we conform first, or we can conform and report? All right, let's adopt substitute. Can you retract your motion, Senator Black? All right. All right, so the motion is to adopt the substitute. All those in favor say aye. Aye. Any opposed? Okay, now the motion is to conform House Bill 1987 to 1490 and report the bill. The committee will vote. Oh, who's got Spruills? Who's got Lionel's proxy?
Thank you. Thank you very much.
All right. Thank you, Delegate. Okay, I just want to remind the committee members, if you haven't gotten back to Mark on your RSVP for our dinner, please do that, because I've got to put in the request for some of the food. With that, the committee is done with their business for the year, and I want to thank you again. Committee will rise.
Mr. Chairman.